Bienvenido, everyone, to our 2025 California Employment Law Update. My name is Rob Carroll, and I'm partner here in the San Francisco office. I wanted just to say that we're going to wait a little bit to make sure that everybody who wants to attend can get hooked up and be present. So this is a good time if you want to grab coffee or bang out those last couple emails. Go ahead and do it, and we will get rolling as soon as I get notice from our folks that we have more than a quorum. Right now we have 140 or so of you guys registered, which we are super excited about. All righty, so I've been given notice from our production crew that we have, it looks like 71 people already on. So with that quorum, I think we should get rock and rolling. Really excited to have everybody join us for today's program. We have a star-studded crew that is prepared to entertain you on some very important aspects of California employment law, not just the new laws that will start on January 1 of 2025, but also some very important laws that went into effect earlier this year and are evolving, as well as essentially we'll be attacking the presentation chronologically and actually beginning with some new laws that did not make it into effect and were either vetoed by the governor or didn't make it for other reasons, because as everyone knows, 2024 is a very special year in both national and California politics. And there are reasons why the slides that we'll show you about the laws that didn't make it into effect did not, but they're not going away anytime soon, we don't think. So with that, again, our panel today, presenters, I did a rough count, and even though I don't look a day over 33, I've been doing this for 4+ decades. And if you add my experience to that of my partner, Lynn Fiorentino, my partner, Jeff Weston, and our awesome associates, Brett Young, Noah Wu, Sai Paspalati, Alex Refuse, and Marissa Rael, you're looking at least 80+ years of experience in this area. And we're going to bring it to bear for you in today's content. As I said, one of the things that we're doing is organizing our agenda essentially chronologically. So in terms of the agenda, once I conclude the introduction, I'll introduce Sai Paspalati, who's a resident here in our San Francisco office, to talk about the bills that did not pass, and also a couple of slides on wage increases that will be going into effect. After that, we will go to Brett Young and Alex Refuse from our LA office, who are very experienced, as we all are, with the PAGA amendments that went into effect on July 1, and then were supplemented on October 1 of this year, and talk about those in depth and some strategy around that and any companion wage hour class actions that you may be dealing with or that companies may be dealing with. After their presentation, our LA partner, Jeff Weston, will be talking about protected characteristics intersectionality, one of the new laws going into effect on January 1, along with race discrimination, including hairstyles and also local enforcement, and the new Freelance Worker Protection Action Act. After that, our partner Lynn Fiorentino from here in San Francisco talk about whistleblower protections posting. driver's license, new law regarding that, and victims' time off, as well as some amendments to the paid family leave. And then Cy will come back to talk about the social compliance audit legislation. And I will then take paid sick leave for agricultural employees, because agricultural labor is one of my areas of expertise. And also we'll conclude with me and Marissa Rael from our LA office talking about SB 399 and the future of captive audience meetings in California. All right, so without further ado, one of the things I would like to do preliminarily is say we want this to be as interactive as possible, given the size of our crowd, and we do have 90 full minutes that hopefully will allow for lots of questions. We have our associate Noah Wu, who is really the brains of the entire operation, and I want to introduce him and have him talk to you about the procedure we'd like to see with questions and answers. So go right ahead, Noah.
Thanks, Rob. Hi, everyone. Very excited to have you join us today for this presentation. As Rob mentioned, if you have any questions during this presentation, please utilize the Q&A box at the bottom of the screen. Your questions will be only directed to the panelists of this presentation, and we will try our best to answer all the questions. And if for some reason we're not able to get to your question, we will make sure to reach out to you after the presentation. Otherwise, our contact information will be provided at the end, or you can just go to our firm's website to find our information. Okay.
Also, with regard to questions, no, folks can check a box if they want to be anonymous. That ability is there in the chat, right?
It might not be, but it will be anonymous in terms that no audience member will see who's writing these questions. So it will only go towards the attorneys here.
Okay, so when you have a question that you may want the panel or whomever's presenting to answer, or anybody else who's interested, you won't be telling the name of the questioner, correct?
Correct. We won't be revealing who's asking the question. So even if you feel like it's a dumb question, please feel free to ask it, and we'll answer those questions. Yeah.
All right, that's perfect. Okay, so with that, unless anybody else has anything preliminary to share with the audience, let's introduce Cy Pasqualati. Cy, let's talk about the bills that did not pass this year.
Great. Thanks for that amazing introduction, Rob. As Noah mentioned, we're very excited that you're all here, and we'd like to kick off this presentation by discussing a few bills that would have impacted California employers but did not pass this year. So starting with SB 1047, this bill was seeking to regulate and establish public safety standards for developers of large AI systems. The governor vetoed this bill due to the burden that it may cause to AI companies, but he still believes that safety protocols and guardrails should be in place. With larger companies now finding innovative ways to use AI, we expect that there will be future legislation regulating the space. And similarly with AB 2930, this was also known as the AI Safety Bill. This was seeking to regulate the use of automated decision tools, or ADTs, to prevent bias, particularly in employment. This was also vetoed, but we do expect this to be an ongoing topic of conversation and discussion, and possibly a future bill. With AB 2494, this would have required employers to provide written notice of COBRA benefits in person and via email following termination or reduction in hours. As you can imagine, this is a huge departure from what the existing law is, which requires 14 days mailed notice of COBRA benefits after a qualifying event, but this did not pass. Under SB 1116, striking workers would have been eligible for unemployment benefits after a 2-week absence due to a trade dispute or a strike.
And with regard to that particular statute side, that'd be a major departure from what has always been the law in California since I've been practicing, which is if you are on strike, you are not qualified for unemployment benefits.
Exactly. And this absolutely would have been a major departure. And was a huge topic of contention, but this did not, of course, pass. SB 1022, this would have extended the tolling deadline for the Civil Rights Department to file a class complaint from 3 years to 7 years. The governor vetoed this bill because he stated that the 7-year statute of limitation is too long, significantly longer than the existing statute of limitations for other civil rights or civil actions. So if someone brought a class action litigation on behalf of employees, that has a much shorter statute of limitations. However, Governor Newsom did say that he's encouraging the legislature to try again next year with a more reasonable period. You know, as you can imagine, with all of these bills, these decisions will inevitably affect discussions on pending legislation, and we may see another version of these bills again. We'll, of course, continue to keep an eye on any developments.
All right, and then Sai, also there's some changes coming in the higher state minimum wages on January 1, correct?
Yes, absolutely. So the minimum wage is going to be increasing. Starting January 1, the state minimum wage is going to increase to $16.50. This is up from $16 per hour. Some cities and counties also have higher minimum wages, so we always recommend employers and HR personnel to check the local ordinances. So for example, San Francisco's minimum wage is currently $18.67. And in 2025, the rate in West Hollywood is going to be jumping to $19.65 for non-hotel employees. I believe West Hollywood is currently the highest minimum wage in the state so far. There are also other bills that went into effect this year that will affect the minimum wage in certain industries. So, for example, the fast food franchise bill was passed in April this year, April 2024, that raised the minimum wage for employees working in franchises to $20 a year. Similarly, minimum wage for certain healthcare employers also increased this year. And the minimum wage is dependent on what type of facility and the type of employer that you are. So lots of changes that have happened in the year and also coming. So this also means the pay levels for exempt employees is going to change. The minimum salary threshold for exempt employees is twice the state minimum wage. And in 2025, the minimum salary will increase to $68,640. This is about $2,000 more than this year. On that same vein, certain computer software employees can be exempt from overtime if they meet a specific salary threshold. For them, the minimum monthly salary is going to increase to a little over $118,000. This is about $3,000, a little more over $3,000 from the prior rate. And also the licensed physicians and surgeons minimum hourly rate for overtime exemption is also increasing. That's increasing from $101.22 to $103.75 per hour. So a good thing to track all of these wage increases. But if no one has any questions, I will pass this on to my colleagues, Alex and Fred.
One thing to emphasize is keep awareness levels up for those local changes, like in West Hollywood, San Francisco, LA proper, that sort of thing.
Yeah,
And
your question about that, about where we can find the region specific. Yes. So typically, you know, an easy way would be to Google. Each city, county will have their own website with their minimum wage. Berkeley law also tracks minimum wages across the state, location-wise, and that can be found on the California website as well, like state websites. We can absolutely share that link if that would be useful.
Yeah, and each county has their own website too. So if you visit these websites, they should have a posting of what the minimum wage is for each region. So that's how you can find out what the rate is.
That's a great question. Thank you for that. Now we're going to move to the new PAGA amendments. And as many of you, I've checked our list, and many of you are clients and have had some experiences with wage hour class actions, unfortunately, since right around the turn into the 2000s. And as that evolved, we then had the original PAGA statute that was passed in 2004 that Brett and Alex will be talking to you about in terms of the amendments now after 20 years and how that came to be. But good to keep in mind that there's sort of two separate tracks here. And we're talking about the PAGA statute and also any potential interplay with wage hour class actions that may have already been filed. So with that, Brett, Alex, take it away.
Thanks, Rob. So hi, everyone. Alex and I are going to be covering the PAGA amendments today. We'll start with a little bit of background about the legislation and what the problems were with the bill and how courts had interpreted it and why the amendments were necessary. And then we'll talk in depth, but not too great a depth, about considerations for employers moving forward and how these amendments might affect you and some things that you might want to think about strategically in terms of taking advantage of the amendments. And so with that, Noah, if you could flip to the next slide, please. I don't know if any of you have seen this picture. It went, quote unquote, viral in the employment defense space a couple of years ago. What this is a Rolls-Royce with the cute or cool or despicable, depending on your perspective, license plate that says Mr. PAGA. This car, as I understand it, is driven by a plaintiff's lawyer who works out of the Valley here in LA, who files a lot of PAGA cases and apparently thought that it was a good idea to put that on the license plate of his $500,000 car. You may, for those of you in the Sacramento area, have seen this car on billboards. You may have seen other billboards related to PAGA reforms late last year or early this year. As most of you or all of you know, California has a unique bill called the PAGA, the Private Attorneys General Act of 2004, that allows employees to step into the shoes of the state and to seek penalties for alleged labor code violations on behalf of the state. This bill was put into place by Governor Gray Davis. I believe it was after the recall vote had happened and he was going to be recalled, but before he had actually left office. And so I suppose it was his final gift to employers.
To say the least.
Yeah, to say the least. And what it did, or what its purpose was to allow employees to step into the shoes of the state as an enforcement mechanism in a sort of a gap between the state's limited resources to enforce the wage and hour rules and what are functionally the robust resources of the plaintiff's bar. And so it allowed an individual who was allegedly aggrieved to seek statutory penalties on behalf of themselves and other allegedly aggrieved employees for certain labor code violations. Over the years, the statute was expanded and, in my opinion, abused and sort of taken out of control by the plaintiff's bar. And it was used to avoid essentially every control or restraint that a court or a defendant employer might have when fighting a proposed class action. And courts had allowed individuals with time-barred claims who could not themselves pursue PAGA penalties to pursue them on behalf of others. Courts had allowed individuals who did not personally suffer a violation to seek penalties on behalf of others. It had just spiraled out of control. What's worse is the way that the plaintiff's bar used the PAGA, and that is they would file these claims knowing that they did not have the same restraints or controls as a proposed class action, and take somewhere between 30 and 35% of a proposed gross settlement amount. Whereas under the statute, the employees were only receiving 25% of the net settlement amount. So in other words, employees were receiving pennies on the dollar in any PAGA settlement, while the plaintiffs' lawyers were buying themselves Rolls Royces, Bentleys, etc., with cool license plates. Reform was clearly needed. And I just want
And Brett,
to back
in
up.
addition to that 25%, the other 75% allegedly went to the state, right?
Yes.
So, but it still had to be paid by the employers on top of anything that might be involved in that wage hour class action that likely was also filed, right?
Yes. And thanks for that. And I should also note here that enterprising plaintiffs' lawyers, or depending on your view, enterprising plaintiffs' lawyers, we're
I like
filing.
despicable better was good. I like that.
Yeah, we're filing PAGA claims separately from their proposed class claims. And so I mentioned briefly there are controls in place in a proposed class action case that the litigators on this call or the recovering litigators who are now in-house will be familiar with. And they allow the court and the defendant to sort of fight against a proposed class action. Those do not exist in PAGA cases. And so in addition to the issues with things like standing and a statute of limitations, plaintiffs' lawyers were also filing PAGA claims separately from their proposed class claims. And this allowed them to force defendant employers to fight cases in two different forums, to fight two separate lawsuits. And it became just generally an extreme burden and almost like a business tax on employers in the state to have to address PAGA claims given the limited remedies that they had to combat them. And so earlier this year, trade associations and action groups banded together to create a ballot initiative to overturn the PAGA. The ballot initiative secured enough votes to actually be placed on the ballot in November, and that led to these amendments. And so we can go to the next slide, Noah, and I'll let Alex talk about some of the key changes.
Yeah, thank you very much, Brett. So yeah, like Brett mentioned, in response to this ballot initiative, Governor Newsom and the legislature worked on amendments to the PAGA that would satisfy both groups on both sides of the issue, rather than to avoid, in theory, the PAGA being totally wiped out through the ballot amendment. This resulted in the passage of two bills that we will discuss today. We're not going to get into the weeds on either of the bill, but we want to present you with an overview of the changes and why they're important to you and to your business. It's also worth noting here, before we go into those changes, that there are still a lot of details that need to be worked out and addressed with the amendments, and there are unanswered questions to us as defense lawyers about how certain procedures for the amendments will work. We're going to cover 4 key changes of the PAGA with you today. They are not all of the changes brought by the amendment, but we perceive them as being the most impactful changes. In general, the amendments limit the scope of PAGA actions and reduce penalties for employers that have taken all reasonable steps to comply with the labor code obligations. I put reasonable steps in air quotes because the statute sets forth some exact procedures that employers can do to show that they are complying with the labor code. And we'll go into those in greater detail shortly. But if you really take anything away from today's presentation, we hope that you take away the need to be proactive and to be focused on prevention. To get the most out of the PAGA reform, an employer needs to be proactive about training and audits and about compliance with the labor code. The fewer employees who have a violation means the smaller proposed PAGA group. Regular trainings and audits can lead to penalty caps under these amendments, so it's important to pay attention to those things. So before we go into the changes, it's important to know to what claims these changes will apply. So the amendments apply to PAGA civil complaints and LWDA letters submitted or filed after June 19th of 2024. So that now takes us to the 4 changes that we want to highlight for you today. Two of them I'm just going to highlight briefly now. We're going to cover them in greater detail on the slides to come. Those are changes to the penalty provisions and the cure provisions. Importantly, the amount that an employer may have due in penalties is being changed and reduced. And an employer has now ways that there were always ways to both, quote, cure a violation of the labor code, but the PAGA now sets forth in greater detail how that can be done, which there's still some ambiguity around that issue. But the two key changes we can talk about now are standing and this early evaluation conference. So standing is, for those who are unaware, it's a legal term of art. It means a person needs to have personally experienced some sort of injury or wrongdoing themselves before they can bring a claim. And for whatever reason, courts interpreted the PAGA in a way that did not require PAGA plaintiffs to have experienced certain violations for employees whom they sought to represent in these PAGA claims. The amendments to the PAGA, importantly, now require PAGA plaintiffs to have personally suffered the labor code violations for the employees whom they seek to represent. This should go a long way in limiting PAGA claims and making sure that they don't grow beyond the alleged violations that the plaintiff experienced. Next.
Alex, we got a question. If you could just explain to some of the folks what LWDA stands for.
Sure, yeah. So that is, the LWDA is the administrative body that governs, essentially, it's a governmental agency that oversees workforce in the state of workers in the state of California. They set forth regulations that apply to businesses. And before an employee can file a PAGA complaint, they must first file a letter, essentially just mail a letter to the LWDA, setting forth the grounds for their complaint. It is a procedure that they must do. They must administratively exhaust that procedure before they're allowed to file their complaint in state court. And let me see, was there another question? We can come back.
I think you can get into the other question as you guys get into the.
Yeah, I think we can cover that one as we get into greater stuff. So we'll come back to that one. So that is standing. The next issue then is this early evaluation conference. So for employers with at least 100 employees, they may ask the court for an early evaluation conference. This is one of those things that I mentioned earlier that we're not exactly sure how it's going to function in real time. We know that it can stay the case. We know that it likely would function like an early mediation in the case. And we know that an employer must submit a statement indicating which claims they intend to dispute and which claims it intends to cure. However, we don't know the exact procedure through which this conference will be held. So for example, will it be the judge? Will it be some sort of labor and employment practitioner, like a mediator or an arbitrator who starts moving into this field to work and evaluate these disputes? We don't really know. And for those reasons, we're hesitant about them because we're worried that, for example, when in these statements, being required that an employer must set forth the claims which it disputes or intends to cure, it's possible that certain statements against admission could be made at these early conferences and later used against employers down the road. So we're hesitant about using the early evaluation conferences until we know how they're going to function in real time.
That's very well put, Alex. And also where there's already some wage hour class action, separate actions already on file, how those admissions against interest might be used in the greater case is really unknown. But thank you for that, pointing that out.
Absolutely. And now we're going to move on to the next slide and talk about the changes in our penalty provisions.
This is me. I will say before I get into this slide and some of the impact of it, that I think this may be the single most important component of the new PAGA amendments, and it's the penalty reduction provisions. Alex touched on it briefly in the last slide, but we think it's important enough to go through it in more detail with you all. And I'm just going to read from the slide here. So under the new penalty reduction provisions, If the employer can show that it took all reasonable steps to comply with the labor code before receiving a PAGA notice or a plaintiff employee's request for personnel records, the available penalties will be capped at 15% of the penalties sought. When an employer can demonstrate that it took reasonable steps to comply with the labor code within 60 days after it received the PAGA notice, the available penalties will be capped at 30% of the penalties sought. So just as a quick example and with some really basic math that I'm sure all of you can do, this can reduce your potential exposure in a PAGA case by 85 or 70%. And so if you're looking at a PAGA claim where a plaintiff is seeking $1 million in penalties, which would candidly be low in one of these cases, you're talking about reducing your potential exposure by $850,000 if you have taken steps to comply with the labor code before receiving the notice, and something like $700,000 if you take those steps after or within 60 days of receiving the notice or the records request. I want to talk a little bit about what a reasonable step is, because that is obviously very important, and the word reasonable is doing a lot of heavy lifting in this particular sentence and in the statute more generally. Thankfully, the statute provides information about what can or will be considered a reasonable step to comply. And I'll just read from the statutory language. It says reasonable steps may include, but are not limited to, any of the following: periodic payroll audits and taking action in response to the results of the audit, disseminating lawful written policies, training supervisors on applicable labor code and wage order compliance, or taking appropriate corrective action with regard to supervisors. Whether the employer's conduct is reasonable shall be evaluated by the totality of the circumstances and take into consideration the size and resources available to the employer and the nature, severity, and duration of the alleged violations. Importantly, the existence of a violation, despite the steps taken, is insufficient to establish that an employer failed to take all reasonable steps. So where does this leave us, and why is this important from a strategic perspective? Well, if you want to claim that 85% reduction in potential penalties, you will need to do things, or you will need to be able to show and demonstrate that you have done things like periodic payroll audits, that you are disseminating lawful written policies, that you're training your supervisors, and that when you learn both employees and supervisors are not complying either with your lawful policies or with the California Labor Code or applicable wage orders, that you are taking corrective action to ensure compliance. We expect that this area will be heavily litigated because the plaintiff's bar will not roll over and take an 85% reduction in penalties. With that said, there are some things that you can do right out of the gate and on some sort of rolling basis, and what that looks like, we're not sure yet, in order to ensure that you can claim that reduction in the cap in the penalty. And I want to just say, we understand that the time and cost spent on regular audits and trainings and the sort of workforce management and oversight this is asking for is not easy, and it's not insignificant, but the potential, I guess I'll call them savings, or the potential reduction or cap in penalties is enormous. And this is a huge benefit to employers who are proactive and take those steps to ensure compliance with the California Labor Code and the applicable wage orders.
I would also add, Brett, the statute uses that term reasonable quite a bit, but for those of us that are veterans and have participated in, quote, an early mediation or two, reasonable for our colleagues in the plaintiff's bar I've never seen it below $1 million, and I've seen it, at 15, 20, $40 million. So what you're saying is a good point, irrespective of if you've had a PAGA notice filed or not. Just making sure you stay on top of these things, as Alex was talking about before.
And Alex and I have, thanks, Rob. And Alex and I have mentioned this a couple times, but it's part of why we're beating the drum about being proactive. And it's because prevention here is the best cure under the new PAGA amendments. And so what it means to be reasonable, again, is something that's up to interpretation. I don't think, although there's no specific case on this yet or any sort of guidance, that you need to do an annual audit of every single one of your policies. For example, the overtime rules don't change all the time, although Sai mentioned that some of the exemption minimum payment requirements will change. But things like your policy telling employees to record all time worked, not to work off the clock, etc., those don't always have to be updated. You don't have to review them potentially every year, although it might be a good idea. But some policies, like your meal and rest break policies, and those of your clients for the lawyers on this call, might change more frequently. We get 1 to 2 big meal and rest break decisions from the California Supreme Court every year or so. And it is certainly worthwhile to update your policies, or at least review them and document it after those decisions come down. The same thing is true of something like a periodic payroll audit and then taking action in response to the audit. I don't think the statute, and again, it's not totally clear, requires you to do a full audit of all of your employees every year. But could you do something like a 10% audit to ensure that your employees are being paid overtime at the correct regular rate on an annual basis? That seems to be reasonable and is something that you as an employer, or you as a lawyer advising your client or your in-house clients, could point to and document it and say, look, here are our reasonable steps to ensure compliance. We did a 10% audit across a cross-section of our business. We found these issues and we immediately addressed them. Those are things that you can add to your to-do list. And this training hopefully is a reminder to move them up your to-do list, or to maybe put a gold star next to them to ensure that they're on the priority portion of your to-do list, because this is really going to be a huge benefit to the business, to your clients, to whomever you're working for, to do these regular audits, because they can significantly reduce your exposure in a PAGA case.
It creates a good record for us as your counsel to confront the plaintiffs with in these early evaluations, or who the hell knows who's making these, trying to get the parties together to make decisions here. But great point, Brett.
And I'll just say the one last thing. I know a lot of our clients do this. We encourage them to do it. A really good thing to do from a reasonable steps perspective is something like an attestation system in your timekeeping system. For those of you that aren't familiar with it, it's essentially a series of prompts in your electronic timekeeping system that will flag for employees a potentially non-compliant meal period, and at the end of a shift, give them an opportunity to answer questions about both meal and rest periods. And it's ultimately sort of becomes an automated or automatic function for employees who are punching in and punching out. And it's the type of evidence, again, that shows reasonable steps that you as an employer, or you as a business, or whatever your relationship is to the business, are taking steps to ensure compliance with a very heavily litigated area of the labor code. And I'm happy to answer questions about those systems, maybe offline or later as part of this training. But for now, I'll turn it over to Alex for the next slide.
Thanks, Brett. So here we are. We're at the point in the presentation where we're really going to avoid getting into the weeds. With that said, we want to give you a few thoughts from a strategic standpoint about what to do if you receive a PAGA notice letter or a PAGA complaint now that the amendments have passed and are law. This idea of a cure comes up in a few different places in the statute, and it's the first thing an employer should start with when receiving a notice. But it's important to note that it doesn't always mean the same thing in each instance. So for example, for wage statement violations to cure, an employer may cure by showing that it provided fully compliant wage statements to each allegedly aggrieved employee during every pay period where a violation occurred, going back 3 years from the date of the notice. Where the employer cured and took all reasonable steps to comply with the law, then there would be no penalty. For all other violations, a cure involves correcting the alleged violation and making all allegedly aggrieved employees whole. And that is a broad thing here. So that means paying all unpaid meals, premiums, wages, etc., going back 3 years from the date of the PAGA notice, plus a 7% interest and plus reasonable attorney's fees. So with those in mind, I know what you're thinking, especially for the wage statement. Curing seems so easy. It seems so good. Why would we not want to cure things? And it's going back to what we talked about before and how the cure process might be used against you, similarly to how it could be used against you from that early evaluation conference. If you go and immediately cure things when there is a pending class action running concurrently to or at the same time with the PAGA action, statements or going and curing could be used as an admission against you that, look, you were doing things wrong and you had to fix all of your policies, and that you have to, and that's essentially that you were not in compliance with the labor code for everything else. So we want to be careful when it comes to curing. In some instances, it could be useful, but in other instances, it might not be what you want to do, especially where there's a pending class action. And those are some important considerations that you might want to take if and when you receive a PAGA letter or a PAGA complaint. So with that, we have a few final thoughts.
So I'll handle the first point here, and then Alex will close on this final thought slide. So the new statute provides employers with a host of options to mitigate their potential exposure with a PAGA claim. Ultimately, in order to take advantage of those mitigation options, employers need to be proactive and evaluate PAGA claims as soon as they receive a notice in order to invoke many of these provisions. So there's a few questions that we think employers should be thinking about once they receive one of these letters from the Labor and Workforce Development Agency, which is the LWDA that Alex was talking about earlier. The first is that, is there anything that can or should be cured once you receive an LWDA letter? For example, are there any issues with your wage statements such that there is a facial violation, like your corporate name and address are not correct, and that's something that you can fix and immediately distribute new wage statements? The second, what efforts, if any, has the organization taken to ensure it complies with California law? I went over that slide in detail. And again, this can significantly reduce penalties if you have taken those reasonable steps, because you can claim the 15% cap. The third question that we think employers should be thinking about, or lawyers advising in-house clients or outside clients, is if no recent compliance efforts have been taken, should any be taken within 60 days to invoke the 30% cap on penalties sought? So remember, if you have taken steps before you receive the LWDA letter or you receive a request for records, there's that 15% cap. But the statute also allows you within 60 days to take immediate steps to address the allegations in the letter, and that will allow an employer to claim a 30% cap on penalties sought. So when you receive one of these letters, if you are able to quickly evaluate and analyze the allegations in the letter, and you realize that there's a potential issue perhaps, one of your departments doesn't have compliant meal and rest break practices because there's a manager who isn't enforcing that, or because the manager is denying employees meal and rest break premiums, things like that. Should you take action immediately to discipline that employee, to bring the department into compliance so that you can show the steps you've taken and claim that 30% cap? And then finally, there's a fourth consideration. Alex mentioned the early neutral evaluation conferences. What those do is allow the employer to decide whether or not to dispute any of the claims. As an employer, if you do not intend to dispute the claims, the early evaluation conference essentially functions, or I guess in theory will function as a sort of early mediation whereby you could resolve some of the claims. Alex is going to talk about this in a minute with whether it makes sense to cure, and Rob mentioned it earlier. In these cases where there's a tandem or a pending proposed class action, it may not be the best strategic decision, but it's certainly something to consider. And so with that, I'll turn it over to Alex.
Yeah, and with some of our final thoughts, we really want to go back to this idea of whether it's a good idea to cure. And the answer is not always. It really is a case-by-case analysis. Because most PAGA causes of action are brought with underlying wage and hour class claims, it may not make sense to go forward with the cure procedure because it does not entirely do away with the class claims, which often go back 4 years from the date of the filing of the lawsuit. If there are underlying class claims that are settled, most PAGA claims would also settle for a fraction of the class settlement, so it may make more sense to not go forward with the cure procedures. However, where there are a limited set of claims, such as only wage statement claims where no penalties could result, it may make more sense to cure certain violations as long as it doesn't impact the underlying class action.
That's a great point, Alex. And I tend to be cynical, as I think all of us who practice regularly here, with regard to thinking that your latter advice is the best. But Noah, you had something else to add before we jump on to Jeff?
Yeah, and I was going to just add, just remember the new PAGA has a standing requirement. So to the extent the actual employee doesn't have any of these like labor code violations, you might just be able to defeat the claims based on standing. So just recall that's something new and something that's very powerful for an employer.
Yeah, without getting into all the cure and all these other accoutrements, if you will, of the amendments. Great point.
And then there is just one last thing. There is one exemption. So outside of everything we just covered, there was AB 1034, which extends the current January 1, 2028 expiration date of the PAGA exemption for construction industry employees. For those employees, rather, who perform work under a valid collective bargaining agreement. So it extends, it applies to those employees who performed work under a CBA in effect anytime before January 1, 2025 to 2038. So it really extends that date to which it applies.
The associations were well represented in Sacramento when these negotiations were going down. Good point, Alex.
Yeah, a 13-year extension is quite the extension, so I must say so. But with that, we will pass it along to Jeff Weston, who will take on the next section on intersectionality.
Thanks, Alex. Yeah, so in PAGA, we honestly could have spent the entire presentation on it. And unfortunately, it's just not going to go away because that attorney's fees provision is still going to be there. And so we'll still see PAGA claims, but hopefully these tools that Alex and Brett went through will help alleviate some of the pressures that we've all been feeling with these PAGA claims. So I wanted to touch briefly on a few updates, and none of these updates are major or groundbreaking, but they're certainly worth knowing so that you can review policies, update policies, train staff, things like that to make sure that things are done correctly so you're not hit with a claim. So the first one is SB 1137, and it involves intersectionality. So on September 27th of 2024, Governor Newsom signed this bill, which clarifies that FEHA, so California Fair Employment and Housing, the UNRRA Civil Acts, and some provisions of the Education Code cannot just focus on individual protected traits, but also on the basis of the combination of two or more protected traits. Now, the reason that this isn't groundbreaking is that there was already a Ninth Circuit Court of Appeals decision back in 1994, where the Ninth Circuit held that protected characteristics might combine and interact in ways that weren't necessarily captured when considering each characterization in isolation. And that's, for those who want to look up the case, it's Lamb versus University of Hawaii. And in that case, an Asian American woman and law professor claimed that the law school, University of Hawaii's law school hiring committee, had discriminated against her on the basis of her sex, race, and national origin. And so the lower court sided with the university because that same hiring committee had demonstrated and had recommended an Asian American man and a white woman, right? However, the Ninth Circuit reversed the lower court's ruling and held that when an individual claims multiple bases of discrimination or harassment, it may be necessary to establish whether the discrimination or harassment occurred on the basis of a combination of these factors, not just on one protected characteristic alone. So what's relevant here is that we could see that, right? If somebody files a lawsuit, you could kind of see this kind of combination of different claims. And in part, that may provide some protections for the individual to get over a motion for summary judgment to kind of dismiss the claims. And then the other point that I wanted to mention with this one specifically is a lot of the times when employers receive discrimination claims, one of the first things that they do is they kind of conduct an analysis to determine, okay, well, we know we didn't make X decision on the basis of race or age or national origin or anything like that. And so we will demonstrate that by highlighting how many Asian American women we have in the workforce, or African American, or whatever the protected character is, or individuals over the age of 40, right? And so you may need to, that analysis will obviously be important still, but you may need to take that a step further, right? And look at the combination. So not just, for example, as the Lamb versus University of Hawaii case, not just Asian people in general, but also Asian women, and kind of take that analysis a step further.
So it's a great point, Jeffrey. And also, like back in 1994, there were only really 8 or 9 protected statuses, and that's grown, I think, to latest is like, what, 24 or something, both federal and state. So there's a lot more potential for overlap today than there was back then.
Definitely. Yep, definitely. Okay, so the next is AB 1850, and this involves hairstyle. So again, this isn't a huge change because in 2019, the Crown Act, which stands for the Create a Respectful and Open Workplace for Natural Hair, that was enacted, and that protected hair textures and hairstyles in the workplace. And this primarily focused on addressing workplace dress code and grooming policies that prohibit natural hair. And some of the examples they gave were afros or braids or twists or locks, which could potentially have a disparate impact on individuals. And Section 1D of the Crown Act states that workplace dress and grooming policies that prohibit natural hair are more likely to deter Black applicants than any other group. And so the Crown Act focused on that. And the Crown Act added anti-discrimination provisions that included language that said traits historically associated with race, right? And so the word historically through this new AB 1815 has been removed because it was vague and confusing. And to be honest, I agree. I don't know what historically means in this context. And so they just removed that. And so this change may seem minor. However, employers should still review their grooming policies to ensure that the existing policies are acceptable and do not have a disparate impact. Sometimes with grooming policies, especially in a place like California, is if you make them gender specific, so tight and revealing clothing, things like that are more geared towards women employees, that could have a disparate impact. So our recommendation with AB 1815 is take a look at your dress and grooming standards and make sure that as you read it, you're not seeing any kind of disparate impact that could potentially impact different groups of a protected characteristic.
I think also, Jeff, the fact that these are added to the Unruh Civil Rights Act expands it beyond employers to housing, public accommodations, businesses, things like that, where
Yeah,
it was not technically before.
Yeah, it's a great point. And the Unruh Civil Rights Act, some retail establishments may be more familiar with this than others because they're hit with these ADA type of lawsuits where somebody will come into their store and they can't open the door. Their door doesn't have the right amount of pressure, or maybe the desk is slightly higher. And so this would be another avenue that somebody like a customer, for example, could sue if they feel like they've been unfairly discriminated against by the business on the basis of their hairstyle. So that's a great point. Thanks, Rob.
You got it.
Okay, so the next one, and this one's a little bit more interesting, is SB 1340. And so Governor Newsom again signed SB 1340 into law, which mandates that the Civil Rights Department collaborate with local agencies to prevent and eliminate unlawful practices of discrimination, harassment, retaliation. So these local agencies may now play a more active role in handling discrimination complaints. Which I think the goal is they could provide potentially a quicker and more localized response. Now we'll see the actual practice of it. But just to kind of give a quick overview of the California Civil Rights Department. So this was established and is responsible for receiving, investigating, and adjudicating allegations of housing and workplace discrimination under FEHA. It also has the function and duty and power to investigate, approve, certify, monitor, enforce these non-discrimination programs to ensure that employees, contractors, and whatnot are not being faced with discrimination, harassment at the workplace. And so it requires these aggrieved workers or these individuals to exhaust their administrative remedies prior to filing a lawsuit in court for workplace discrimination. So what that means is they file a complaint with the CRD, the California Civil Rights Department. They can have the California Civil Rights Department investigate that complaint. That's a lengthy process that we'll talk about. But most common, these individuals file their complaint with the CRD, they obtain a right to sue letter, then they file a lawsuit in state or federal court. So that's typically the process, right? So under existing law, prior to this inaction of SB 1340, only the state may enforce FEHA and local governments could not. So, and the state enforces FEHA through the California Civil Rights Department. So there's limited resources and only a handful of offices throughout the state. So the California Civil Rights Department must process around 24,000 complaints alleging discrimination annually and investigates only about a quarter of them, right? And so what this SB 1340 is, it provides kind of the ability of these local governments that may be more centralized and more have kind of a more emphasis on investigating these in a more timely manner, the ability to do so. And so that is going to be important because we'll see how the local government interacts and kind of gets involved. It does clarify that the local enforcement may only occur after the California Civil Rights Department issues a right to sue notice. So they would have to close it, obtain a right to sue notice. Now, my prediction is I don't think this is going to change much, right? Because once an employee actually receives or former employee receives a right to sue notice, you can typically expect them to file a lawsuit, and that gives them typically a bit more leverage than having them go through this process with the CRD or even more so with the local government. But we'll see. I think importantly, though, the statute of limitations provided in the right to sue notice, which is 1 year from the date that is on the notice, will be extended during any local enforcement without prohibiting the potential plaintiff from filing during local enforcement. So what that means is if the local government does take a role and is investigating it, then the statute of limitations will be extended. So I think that's going to be kind of the main point with this. Importantly for employers, local enforcement may only occur after, as I mentioned, issues a right to sue notice, and a city, county, or district attorney in a location having an enforcement unit could now investigate the complaint. So again, I don't think it's going to be a widespread change in the way that these are typically handled, which is either through the CRD, through their investigative unit, or obtaining a right to sue and filing a complaint. However, we'll see kind of how much a city, county, or district attorney kind of gets involved with this. Okay, and then the last one I wanted to cover is SB 988, Freelance Worker Protection Action Act. So this imposes some minimum requirements related to contracts between a hiring entity and a freelance worker. Under the new law, a freelance worker is defined as a person or organization composed of no more than one person, whether or not incorporated or employing a trade name, that is hired or retained as a bona fide independent contractor by the hiring party to provide professional services in exchange for an amount equal to or greater than $250. That's a lot, right? That's kind of a mouthful. So I think I'm going to just highlight the main points of this, which is the act applies to those services listed in California Labor Code Section 277(8)(b)(2), and those are marketing, administration of human resources, travel agents, graphic design, grant writer, and fine artists. So my guess is that the majority of individuals that retain or hire or contract with independent contractors, they probably wouldn't fall into those services. But I think some of the points that this law kind of mandates are still good to put in practice, regardless of the services provided by the independent contractor. So under this law, an agreement between a hiring party and a freelance worker must be in writing and include the following: the name and address of both parties, an itemized list of services, their value and the compensation method, payment due dates, the freelancer worker to report completed services for processing timely payment. And then once a freelancer worker has commenced providing the services, the hiring entity is prohibited from requiring the worker to accept less compensation or to provide more services than previously agreed to. And so that's going to be an important fact, is if things change, you're kind of stuck with what was originally agreed. The law puts in place certain prohibits against retaliatory actions by hiring entities for a freelance worker taking any of the following actions. So again, if you're opposing any practice prohibited by the act, they could bring a private right of action. If you're participating in proceedings related to the enforcement of the act, or you're seeking to enforce rights under the act, those are all acceptable ways for an independent contractor to bring claims. So the act applies to contracts entered into or renewed on or after January 1st of 2025. And I just want to make one note, is California has a continued, I called it disdain towards independent contractors, which may or may not have to do with tax revenue and things like that, but I won't
Yes.
Yeah, I won't get too deep into it. But so we recommend implementing safeguards for independent contractors that you can use. So confirm whether the ABC test, which again, we could spend lots of time going, applies, or an exception exists for the previous tests, the Borello factors, which looks at degree of control and a variety of other factors. And then we always recommend have a written agreement that includes kind of language that protects you, language related to the independent contractor relationship and things like that, because that will help in the event that some individual claims that they've been misclassified. But independent contractors is a bit of a mess in California, but if you kind of enact some of these safeguards, it'll help protect you from some of these claims.
And the nice thing about these slides that Jeff has just gone over is that if you've got anything in progress, they don't go into effect until January 1 of 2025. And for freelance workers, you do have a roadmap here to at least follow what Jeff is advising, because we're all cynical about whether or not everybody working, whether an independent contractor or not, is actually an employee in California, just given how things have gone over the last decade. And with that, unless you have any other concluding remarks, Jeffrey?
No, that's it. Thanks, everyone.
All right. Thank you. Awesome. Lynn? Can you enlighten us on whistleblower protections, posting, driver licenses, victims' time off, and paid family leave?
Thanks, Rob. Happy to do so. Again, welcome to everyone, and thanks so much for attending today. So obviously in California, we've always had really robust laws around whistleblower protection and advising employees, giving them notice of those protections. A new law went into effect July 15th of this year around whistleblower protections posting. This is AB 2299, which some of you may have heard of. And essentially, this is a new model posting about whistleblower protection that's available on the DIR, the Department of Industrial Relations website. The reason this came into effect was that there was a prior sample notice available on the DLSC website, but it had a disclaimer. And the disclaimer basically said that it didn't guarantee that an employer who posted the posting would be deemed in compliance with the whistleblower protection notices. And so the authors of this bill thought it's important, especially for small businesses in particular, to have a model poster that would guarantee that the employer is in compliance with the notice provisions for whistleblower protections. And so that's how this law came about. So it's pretty easy to comply. We've got, and you'll get a copy of our slides afterwards, that link there at the bottom of the slide. If you just go to that, it gives the full posting that's now available, and you'll be deemed in compliance with these laws. So that's what's new around whistleblower protection posting. All right, now if you could go to the next slide, please. Okay, driver's licenses. SB 1100, which will go into effect January 1, essentially prohibits employment materials such as job advertisements, postings, or applications to state that an applicant must have a driver's license. So this is a shift in the law. There is an exception, though, obviously, for certain positions which require that the duties are going to involve driving, i.e. a truck driver or some sort of a delivery driver. You might imagine we see a lot of those these days with Amazon and the like. Those positions, an employer can require a driver's license as part of the application process, unless there's a reasonable belief that an alternative form of transportation would not be comparable. So in the instance of a delivery driver, obviously using a taxi is not going to be the same and as efficient as the person having a car or a truck or something like that. So this law essentially came into effect because it was believed that requiring driver's licenses for certain jobs would discriminate potentially against marginalized communities, and that it, requiring a candidate to have a driver's license or owning a vehicle can perpetuate these broader sort of biases and assumptions that, just because you don't have a car doesn't mean you're not going to be a solid candidate for a job. Interestingly, this law also will prohibit landlords from discriminating against existing or prospective tenants who do not have a driver's license or do not own a vehicle. So it really is two parts to this law, and it'll be interesting to see how this plays out starting next year. Okay, next slide, please. All right, starting in January, we have the Victims' Time Off Bill. This is AB 2499. Essentially, this bill is a broadening of existing time off for victims of what used to be a crime or abuse. And now the definition has been enlarged to include a qualifying act of violence. So essentially what this law states is that it prohibits discrimination, retaliation, or termination of an employee who takes time off for any of the following reasons: jury service, responding to a court order, and making an appearance as a witness in a matter, becoming a victim and needing to take time off to obtain necessary relief for a child's health, safety, or welfare, or becoming a victim and needing to assist a family member who takes time off for various qualifying acts of violence. This particular law was enacted under the belief that the crime survivors and their loved ones who need safety and need to heal after a violent or traumatic event should not have to worry about taking time off and worry about losing their jobs. And so essentially it protects them and gives them the time that they may need to actually get the help they need or the treatment after one of these types of events. It was also enacted, on the belief that particularly low-wage workers, including immigrants and women and workers of color who are especially more vulnerable to victimization, would have the flexibility and the protection to take the time off to heal that they would need, and would ensure that they would still have their jobs available once they were completed with that treatment. What's interesting, like I said, this particular law enlarges in scope the what would constitute a qualifying act or qualifying act of violence, excuse me. And so it doesn't mean that someone has to have been arrested or prosecuted or convicted of a crime. This would include any acts of domestic violence, sexual assault, stalking, bodily injury or death to another person. It would include acts where someone brandishes a firearm or another dangerous weapon at the victim. And it would include situations where the victim feels, either a perceived or an actual threat of use of force against them. So it's a pretty broad scope here, and again, intended to benefit victims and their survivors. All right, if we could go to the next slide, please. Okay, and last but not least, here, the Paid Family Leave Act, AB 2123. This is a new law going into effect as to the PFL, or the Paid Family Leave Act in California. As everyone may know, the prior law permitted employers to require that employees utilize earned vacation time before being eligible to take family paid leave benefits during any 12-month period. The new law prohibits employers from requiring employees to take up to 2 weeks of their earned vacation time before they are eligible to take the PFL benefits during any 12-month period. So this is providing, more flexibility for both the employee and the employer. This particular act was created, on the belief that workers should have access to the support that they need without placing any additional requirements on California employers. And the thought was that, well, vacation time is intended for personal time off, and PFL is a different sort of benefit that is there to support workers who are unable to work because they are bonding or caregiving or something else where they are entitled to take that benefit. So those are the topics that I had to cover, and I'm going to go ahead and pass the baton on to my colleague, Sai, I believe, who is picking back up with social compliance audits.
Excellent presentation, Lynn. Sai.
Thank you, Lynn. Thank you, Rob. Before I jump into social compliance, I saw a few questions that came in that I'll tackle now. The SF minimum wage. So I got a question. Do we know what the SF minimum wage will be? So the SF minimum wage is currently $18.67. That rate is going to stay in place until June 30th, 2025. We don't know yet what the increase might be, but at least for most of next year, that rate will be consistent. And then the second question that I got was about the minimum wage increases for healthcare employers. So this is a bit of a tricky question. Particularly the question was, does that rate increase to $23 an hour include roles that are not a medical position but working in a medical company, such as transportation, caregiver? So this is very statute based. I'll say from like a preliminary perspective that $23, only certain healthcare facilities will get that. So I would take a look at whether you would qualify as, as a preliminary analysis, but whether that includes other medical positions. Yes, covered healthcare employees do include caregivers. Transportation there's like a whole list that I can share the statute with you about what's listed. Transportation workers not typically included if they're not employed by that healthcare employer that is eligible for, or the statute is applicable to. So again, we have to take a look at that, but hopefully that helps.
Thanks for that clarification, Sai.
Yeah, absolutely. Okay, so social compliance audits. Starting on January 1st, 2025, California will require employers to publicly share results of voluntary non-governmental social compliance audits. That is a mouthful. We'll break it down. So what the audit is defined as voluntary non-governmental inspection or assessment of an employer's operation or practices to evaluate whether those operations or practices are in compliance with state and federal labor laws. This includes wage and hour, health and safety regulations, as well as those regarding child labor. So, and I'll flag this for you now, and we'll get into this a little bit more later. So if an employer chooses to go through this voluntary process of an audit, and they're trying to evaluate whether their company is following, wage and hour laws, they might still fall under the statute of whether they need to comply with the reporting requirements. So if we turn to the next slide, Noah, I can go into that a little bit more. So first and foremost, what does the reporting require? The report must include the year, month, day, and time that the audit was conducted, whether the audit was conducted during a day shift or a night shift, whether the employee did or did not engage in or support the use of child labor, a copy of the employer's written policies and procedures regarding child employees, whether the employer had exposed children to any workplace situations that were hazardous or unsafe to children's physical and mental health and development, whether children worked within or outside regular school hours or during night hours for the employer, and then a statement from the auditing company that it is not a government agency and it's not authorized to verify compliance with state and federal laws. And we can turn to the next slide. Perfect, thank you. So the purpose of this is to increase transparency and allow consumers to support companies that follow labor laws, and to inform company shareholders of performance. This is also being done to ensure that audits are accurate. What we are seeing is that companies will often voluntarily hire private firms to conduct audits at their facilities in response to negative press or to otherwise help consumers gain confidence in their business. And in the recent years, this has become quite a big industry, nearly an $80 billion industry for companies to come do this. And due to historic staffing shortages with federal and local and state agencies, these private audits are often the only audit companies will receive of their labor practices. And some publications are pointing out the flaws in this process. So for example, sometimes auditors will certify a company as being compliant, despite that the auditor did not investigate all parts of the supply chain or all shifts of work performed. This has led to reports of auditors missing instances of child labor because they don't inspect, or they only inspect during regular business hours, but not night shifts, for example. And this audit, so, just to kind of go back to that point that I initially made, if the company goes under an audit for their wage and hour practices, they might still need to comply with AB 3234 in that they'll have to, they might need to report under this bill. The takeaways though, and kind of, I'm sure these are some of the issues that you're already spotting about this new change, is first of all, there is no requirement for your business to conduct the social compliance audit. However, if you choose to conduct the audit and your audit would fall under AB 3234, you will be subject to reporting requirements. And the struggle with kind of understanding whether you would be compliant is because AB 3234 includes pretty broad and vague language. For example, it doesn't specify deadline for posting the findings. It doesn't state how long the report needs to stay up on a website. The statute doesn't show what are the penalties for non-compliance. Some of these questions that we've discussed so far may be answered. We're expecting that California labor authorities at some point next year will be expected to provide guidance before enforcing anything. So we'll keep an eye out for that and see what happens, see what they do with that. But ultimately, employers for 2025 will need to assess whether their audits, internal audits, will need to comply with AB 3234. This will be a very fact-intensive process, which is something your legal counsel, including us, can absolutely help you with. But hopefully, when we get that guidance from the labor authorities, we'll have a bit more information on how to go.
And I think, Sai, that would be our best advice right now, is to not jump right into it next month, but to wait to get the guidance from the labor authorities. All right. Well, thank you for that presentation, and check the Q's and A's. There may be something to follow up there for you. And we are now in the home stretch of the presentation. I have one slide for my agricultural clients that are out there. There's a few of you guys. Paid sick leave has now been extended to ag employees who work outside. And so paid sick leave can be used if there are smoky, sorry about that, smoky and extremely hot or flooding conditions, basically responding to things that have been caused by climate change created by a local or state emergency. And also this applies to preventative care, and not just for the employee, but also for family members. And there's no real definition from the DIR of preventive care, but it clearly includes things like annual exams, flu shots, maybe other vaccinations, and it could be construed much more broadly. All right, and then let's proceed to the California Worker Freedom from Intimidation Act, which is one of my favorite topics. If you go to the next slide, Noah. The key here, and I'm going to turn it over to Marissa to go through the actual statutory language, but the key here for those of us that have practiced for a long time under the National Labor Relations Act area has to do with the definition of adverse actions, and that this statute applies to prohibit captive audience meetings on, quote, religious or political matters. And as Marissa will tell you, political matters include labor union issues. So just to kind of move up the punchline in the National Labor Relations Act and union crossover, for those of you that may at some point have faced, I see a couple of you guys have in the past, or may be facing any type of union organizing activities over the many years, the National Labor Relations Board, at least since 1948, has permitted employers to convene captive audience meetings of employees on company time to discuss the facts about what it means to sign a union authorization card or be a member of a union as part of essentially countering an organizing drive. And what this statute does is places this in question on the state level, and there are several other states that Marissa will talk about that have similar legislation. We think there are some issues here, especially because the National Labor Relations Board is a very political agency, and the majority on that board will be changing on and after January 20 of next year from the Democratic Party to the Republican Party, that there's more to this story. So let's go to Marissa, and if you would summarize the statutory requirements.
I will. Thanks, Rob. And hi, everyone. Again, thank you for taking the time to join us today. So as Rob just mentioned, California is actually going to be joining 10 other states that have already enacted similar legislation to SB 399. And those other states are Alaska, Connecticut, Hawaii, Illinois, Maine, Minnesota, New York, Oregon, Washington, and Vermont. And so this law was already signed by Governor Gavin Newsom and will take effect on January 1st, 2025. So just for a quick overview, what does SB 399 entail? So essentially, SB 399 prohibits employers from holding what are known as captive audience meetings. You may be asking, what exactly is a captive audience meeting? So captive audience meetings are meetings where employers express their views on religious or political matters. And these captive audience meetings can also include meetings that discuss the topic of union representation. So this law basically aims to protect employees from being forced to attend such meetings or listen to communications on these topics if they choose not to. So the overall implications of this law are pretty significant. This law now means that California employers cannot take any adverse actions such as firing, discriminating, or retaliating against employees who decide not to attend these meetings or engage in these discussions. Next slide. Okay, so what exactly constitutes a political matter? So SB 399 broadly defines political matters to include anything related to elections, political parties, legislation, regulation, and decisions about joining or supporting political or labor organizations. And next, what exactly constitutes a religious matter? So the law broadly defines religious matters to cover anything related to religious affiliation and practices, as well as the decision to join or support any religious organization or association. And next, we are going to discuss the exemptions to SB 399. And these are really important to know, especially if any of these exemptions apply to any of you. So first up, we have religious organizations. So religious organizations are exempt if they fall under Title VII of the Civil Rights Act of 1964. And next, we have political organizations. So political organizations have an exemption if they require employees to attend meetings or engage in communications about their political beliefs. Educational institutions also have an exemption. So if an educational institution requires students or instructors to attend lectures on political or religious topics as part of their regular coursework, they will also be in the clear and have an exemption from SB 399. Nonprofit training programs are another category with an exemption. So if these programs involve activities related to political or religious matters that align with their mission, then they can also continue with these programs without any interruption. Legal compliance trainings are also exempt, and this is particularly important because it allows employers to conduct necessary trainings to meet their legal obligations, such as civil rights and safety laws, without facing any additional restrictions. And lastly, public employer orientations are also exempt. And this means that new employee orientations, as defined by certain government codes, can also proceed as usual. Next slide. Okay, so how can affected employees enforce SB 399? So if an employee feels that their rights under this law have been violated, there are essentially two options for enforcement. The first option is to file a complaint with the California Division of Labor Standards Enforcement. And the second option is to file an action in the Superior Court, which can allow the employee to seek damages, punitive damages, or injunctive relief. So even though SB 399 will not be in effect until 2025, it is already expected that employers will challenge this law. So there are 3 ways that this law will be challenged. First, employers may argue that this law is unconstitutional under the First Amendment, since the law is seeking to restrict speech based on its content or subject matter. And second, along those same lines, employers may argue that this law is too vague and broad, and consequently is infringing on their free speech rights. And the third argument, employers may argue that the law is preempted by the National Labor Relations Act.
And in particular, on that score, Marissa, 8C is the particular provision of the NLRA that's been in effect since 1935 that has a broad First Amendment right for, even though the statute doesn't cover union or employer rights specifically, there is a broad freedom of speech there as long as the what is being represented is truthful.
Yes, exactly. And Section 8C of the NLRA also has always allowed employers to communicate their views on unionization as long as they don't threaten or promise any benefits to the employees. And yet, as Rob noted, this illustrates how SB 399 is in clear conflict with the NLRA, and because of this conflict, is preempted or could be preempted. Okay, so lastly, with SB 399 coming into effect in 2025, the most important question to think about is, what should employers do? So given these potential challenges, it is really important for employers to review their current policies on workplace communications, especially those communications involving political, religious, or union-related topics. Employers might also want to consider making attendance at these meetings voluntary, and also make sure that their managers and supervisors are familiar with the appropriate ways to communicate on these issues. And finally, as this law may require changes to existing practices, it is advisable for employers to consult with legal counsel to make sure that they are complying with SB 399 and are maintaining a legally compliant workplace. And
Excellent advice all across the board there, Marissa. So this will conclude our agenda for today. We thank, wow, lots and lots of folks that have hung out, even though we spilled over a few minutes. We would mention that those of you that would like to qualify or seek CLE credit, which is me in 3 different states, it's AFS 241210. And unless any of my colleagues have any other points, we really appreciate you guys attending. It's been an active question and answer session going on as well. And you have our numbers and contact information if there's any follow-ups that you guys would like. We are happy to continue offline for as long as you'd like. All right, hearing no comments, many thanks again. And you guys go out and have an awesome holiday season. Really appreciate your time and attendance today.
Thanks, everyone. Take care.
Thanks, everyone.
Thank you.
thanks, everyone.
Thank you.